Hello there, welcome. I'm Amy. This is my very first episode of my weekly employment law updates. This free series is designed to help you stay informed about key changes in HR and employment law without spending hours researching. So each week I'm going to cover recent employment law news from the past week, notable employment tribunal cases, and important employment law changes coming into effect over the coming months so that you're prepared. If you work in HR, consider this a valuable work task. Take 15 minutes with a cup of tea, or simply listen while you're commuting or doing household tasks. Wherever you are, let's stay up to date together. Before we begin, if you'd like to stay updated on employment law and HR developments more regularly, you can check out my Patreon. It's a simple app that you can download, and I'll include the link below. For just £3.50 a month, you'll gain access to a wealth of information, including regular updates and exclusive content. Additionally, if you're a busy HR professional, business owner or employer, you may find my HR resources on my website helpful. www.employmentwithamy.co.uk. I provide a range of ready-to-use resources, including policies, letter templates, compliance updates, aligned with the latest legislation to help you streamline your workload. So let's start with a brief summary of legal changes all employers need to take note on and act on within the next month to make sure that you're prepared, because April, true to fashion historically, is going to be a busy month of change. So first, let's talk quickly about the Neonatal Care Leave and Pay Act, which is an entitlement expected to come into effect in April 2025, providing up to 12 weeks of paid leave for parents of babies requiring neonatal care. This leave must be taken within 68 weeks of birth and is in addition to existing parental entitlements. Employers should have a written policy for their employees to view and for managers to refer to. If you don't have one yet, you can purchase a neonatal care leave and pay policy via my website. I'll put the link in the description at the top. Other changes in April, we've got increases to national minimum living wage. So for those 21 and older, going up to £12.21, those 18 to 20, going up to £10, 16 to 17, going up to £7.55, those 16 to 17 and apprentices going up to £7.55 an hour. Following that, we've got increases to national insurance contributions. So the rate increase has gone from 13.8% to 15%, but there's been a threshold decrease from £9,100 to £5,000 per year. I'd imagine everyone in the business pretty much knows that already. We've also got statutory pay increases. So we've got sick pay going up to £118.75 a week. We've got maternity, paternity, adoption and shared parental pay going up to £187.18 a week. So now let's talk about the last week. By far, the biggest part of the last week has to be the amendments to the Employment Rights Bill. And if you're unaware of what the Employment Rights Bill is, it's a significant legislative proposal introduced by the UK government on October 10, 2024, aiming to overhaul existing employment laws to enhance worker protections and to promote fair working conditions. And we've had some amendments put forward in the last week. So what are they? So the amendments to the Employment Rights Bill were published on the 5th of March 2025. I will cover the main amendments in a second, but if you want to view them in detail, I'll put a link to the Labour news page where they've organised them quite neatly in the description box below, along with the link to the amendment paper itself, under heading 1 and 2. So I've grouped the amendments into categories. Feel free to skip this bit if you already know. So we've got domestic abuse protections, statutory leave for domestic abuse victims, a minimum of 10 days. We've got protection from adverse treatment due to being affected by domestic abuse. Employers must take reasonable steps to prevent domestic abuse for employees and contract workers within the workplace, and a requirement for domestic abuse policies in companies with more than 5 employees. The next category is worker protections and rights. So there's a reintroduction of statutory discrimination questionnaires for workplace discrimination cases, a consultation and introduction of protected paternity and parental partner leave, paid entitlement for carers leave, which is currently unpaid, recognising caring as a protected characteristic under the Equality Act 2010, standardised rates for statutory maternity, paternity, adoption and bereavement pay, and companies with 250 plus employees must publish parental leave and pay policies. We've also got statutory adoption pay extended to self-employed and contractors. We've also got kinship care leave entitlement introduced. The next category, workplace protections and union rights. Employers must prevent workplace violence and harassment, particularly gender-based. Health and safety executive to develop violence and harassment protection guidelines. Expanded right to be accompanied at disciplinary and grievance hearings. Enhanced protection for whistleblowers against unfair dismissal. Trade union representatives gain protections from career detriment and also consideration for promotion. And the last one is employment and labour market reforms. So repeal of restriction on prison officers taking industrial action, increased statutory maternity pay to match the real living wage, an establishment of a working time council to explore a transition to a 4-day working week, the government to report on employer compliance with flexible working duties, strengthened enforcement against companies avoiding employment tribunal awards through insolvency, and strengthened enforcement and support for trade union representatives in career progression. So what happens now? As of 12 March 2025, the Employment Rights Bill has successfully passed its third reading in the House of Commons with a majority of 233 votes. The third reading is the final chance for the Commons to debate the contents of a bill. It usually takes place immediately after report stage as the next item of business on the same day. Now, the bill is scheduled for its second reading in the House of Lords on 27th of March 2025. The second reading is the first opportunity for the members of the Lords to debate the key principles and main purpose of a bill and to flag up any concerns or specific areas where they think amendments or changes are needed. If you're interested to know more about the stages of the process of a bill becoming law, I've put a link in the description to a video that I shared. And if you would like to learn more in general about how things work in the House of Commons and Lords and the different stages that bills go through, I've put a link in the description under number 4. So now let's move on to Employment Tribunal news over the past week. Firstly, we have a case illustrating how not to treat union representatives in the workplace. A Unite representative was deliberately targeted by senior managers who called him a wasp that needed swatting in internal emails. They restricted his union role, encouraged complaints against him, and tried to suppress his health and safety reports. He was awarded £10,000 in compensation for the distress caused. The Trust has since apologised, insisting that the case does not reflect its broader union relationships. I'll put the link to that case at number 5 in the description. So the next tribunal case involves an employee performing a higher band role but still receiving lower band pay. An employment tribunal ruled that North West Ambulance Service must pay £6,021.57 to Daniel Brackenbury after determining that he had been underpaid. Brackenbury took on a temporary senior paramedic team leader role in January 2023. He was initially told that his pay would increase after 3 months, but a manager later revoked that decision. The tribunal found that he had been substantially fulfilling the higher band role rather than just covering it intermittently, meaning he was effectively working unpaid in a higher position, and the judge ruled this was a contravention of the agreement, leading to the compensation order. NWAS accepted the tribunal's findings, calling the situation a complex issue. I'll put the link to that case at number 6 in the description. The third and last tribunal case is a very interesting one. A London nanny, Lei Sang, successfully sued a couple for £39 in unpaid wages after quitting just 3 hours into the job. Miss Sang connected with the parents via Koru Kids and agreed to care for their daughter 3 times a week. In April 2024, she attended an induction session where the parents showed her the child's school, house route and job expectations. Although she did not perform childcare duties, she later decided against the position and resigned the next day. When the parents refused to pay for the induction session, arguing that she hadn't done any actual childcare, Miss Sang took the case to an employment tribunal, and the tribunal ruled in her favour, concluding that she was entitled to be paid for attending the session. Again, I'll put the link in the description below under number 7. And that concludes our weekly update, so let me know what you thought, whether you liked it, whether you'd like me to include anything else going forward. I hope you've enjoyed. I hope we're all a little bit more up to date, and I look forward to seeing you next week. Don't forget to subscribe and hit the notification bell so that you get alerted every time I post a video. See you next week.